So we're now going to join the closing statement provided by the NFSP to phase 4 of the Post Office Horizon IT inquiry, where they detail the failings of witnesses who didn't understand basic concepts like how to answer questions in witness statements, and also the conversations that were happening internally at the post office between staff, including the legal teams, regarding the implicit destruction of evidence during the prosecution of innocent sub-postmasters. Let's jump into the inquiry.
It is submitted that there seems to be a pattern of the Post Office valuing business considerations and the ability to recover funds, whether or not actually owed to them, over the truth, their duties to the court and to justice. The NFSP was concerned to hear that business considerations played a role in the decision whether or not to prosecute an individual, and that their external solicitors do not remember challenging this when it was identified. The NFSP has been shocked by the displays of incompetence by some of those giving evidence to the inquiry, in particular the evidence of Elaine Cottam and Jarnell Singh, call into question the post offices and their lawyers' understanding of basic concepts such as how to answer questions in a witness statement and whether information that is not written down is disclosable. The NFSP was also appalled to hear the evidence of Helen Rose regarding her audit report and witness statements concerning Lee Castleton. It is unacceptable that Ms. Rose told the court on the basis of a blank template that a number of failures applied in this matter, such as the safe being left open when this was not the case. It is unacceptable that she went on to try and undermine Mr. Castleton's character by telling the court he smelt of alcohol when this was not recorded within the contemporaneous documentation and was not true. It is also unacceptable that when asked by the inquiry why she included these within her witness statement to the court, she just said she couldn't remember why. The NFSP submits that this demonstrates a fundamental disregard for ensuring that she was fulfilling her duty to the court and begs the question whether there was anything that those involved in actions against Horizon users weren't willing to do in order to make an example of those challenging Horizon and ensure that prosecutions and the recovery of funds could continue. It seemed that Ms. Rose was unapologetic for her significant part in a case which had life-altering consequences. This also appeared to be the case for Mr. Singh, who, despite being advised that Gareth Jenkins' role as an expert witness had been discredited and that there were instances where the Post Office had breached their disclosure obligations, provided a quotation to the Post Office's public affairs manager that it submitted he knew must be untrue to allow the Post Office to defend Horizon to the public. He seemed equally unapologetic for his part in his role as head of criminal law, or whatever the title may have been, Mr. Singh seemed not to be able to remember. Instead, he compared himself as aggrieved in the same way as victims of Horizon were, because he was in a position to do something and he didn't. His evidence, and that of Elaine Cottam, was shocking in its incoherence, and whether deliberate or not, adds to the obfuscation created by so much of the witness evidence. Touching on legal obligations, another key concern for the NFSP that has emerged from Phase 4 is that those involved in progressing investigations, prosecutions and other processes within and behalf of the Post Office appear to have gone beyond failing to comply with their legal obligations by omission. The NFSP submits that one example of this was an apparent attempt to minimise or destroy written information about issues with Horizon. This seemed to have been based on an idea that if information was not written down, it did not have to be disclosed. The NFSP is appalled to hear that not only were those who were dealing with taking action against Horizon users told to reduce electronic correspondence regarding Horizon issues, for instance the evidence of the witness John Scott, and not to take minutes in relevant meetings, but the people were also told that typed minutes should be scrapped, and it was implied that minutes should be shredded. The NFSP considers that the Post Office must explain to the inquiry and the victims of Horizon why they did not change practices in the light of the advice provided by Simon Clarke on the 2nd of August 2013. See Advice on Disclosure and the Duty to Records and Retain Material by Simon Clarke, dated 2 August 2013. That's Paul 00006799. It's also submitted that the apparent attempt to avoid disclosure of weaknesses in cases against Horizon can be seen in the difference between an offender report and a discipline report. For instance, significant failures in security, supervision, procedures and product integrity had to be kept in the offender report, which was then kept confidential as it was considered to be subject to legal privilege. However, those failures were explicitly not contained within the discipline report, which was disclosed to the person being investigated and therefore could have an impact on the ability to prosecute and the reputation or security of the Post Office. The NFSP was shocked to hear the evidence of Elaine Cottam and Stephen Bradshaw that witness statements signed by them and submitted as evidence in court proceedings were in fact drafted by others and were not their words. Finally, in relation to legal duties, the NFSP was shocked to hear that it was quite a common practice by the criminal law team that there would be a charge of theft and then also charges of false accounting, even when the Post Office's own investigators concluded that there was no evidence of theft in relation to a shortfall. There was evidence from David Pardo on that, Diane Matthews and others. It is the NFSP's understanding that a prosecutor cannot and should not raise a charge where there is not sufficient evidence to support that charge. It submitted that there is evidence before the inquiry which appears to show that the threat of a conviction of theft was used as a threat to encourage those subject to prosecutions to make a guilty plea to the alternative charge of false accounting. In relation to criminal proceedings in Scotland, the NFSP notes that while it was for the Procurator Fiscal to take the decision on criminal proceedings, they were wholly reliant on the Post Office as a reporter and a specialist reporting agency to provide all relevant evidence and to follow the guidance and training given to them by the Crown Office and Procurator Fiscal Service. The continuation of legal proceedings despite known issues. Therefore, it seems clear to the NFSP on the evidence heard that the attitude of the Post Office and those instructed by them in relation to action against Horizon users appears to have been to continue with legal proceedings despite known issues with Horizon. The NFSP submits that it is clear through the Helen Rose report, the associated correspondence with this and Simon Clark's related advice, that the Post Office were aware there were concerns that the data relied upon in prosecutions would not be giving a true picture. And it appears from the evidence that the Post Office were aware Gareth Jenkins knew of Horizon issues at the time. It seems to the NFSP that, at least partially as a result of the likely impact of an investigation on the ability of the Post Office to prosecute postmasters and others, the proposed independent review by an external organisation such as Ernst & Young did not occur. Instead, the Isme Report, a supposedly independent report, but which ended up looking only at evidence supporting the robustness of Horizon, was commissioned. See the evidence of Isme on the 11th of May. On the basis of this, Mr Wilson's position that the Post Office should grit its teeth and get on with it shows that the Post Office prioritised the ability to be able to prosecute above investigating known concerns. In addition, the NFSP submits that it was unacceptable that those within the Post Office, who by then knew of Horizon integrity issues, did not have discussions about pausing prosecutions due to the fear this would immediately cast doubt on prosecutions that had been completed before. See the evidence of David Pardo on the 29th of November. It seems perverse to the NFSP that a prosecutor would not investigate the robustness of evidence it relied upon when it was aware of issues, simply in order to keep prosecuting and to ensure that previous, possibly erroneous prosecutions were not reviewed or called into question. In closing, sir, the NFSP believes that as a result of the actions and failures of the Post Office in effectively creating the Horizon scandal, the Post Office have tarnished this once most trusted of brands. The NFSP is therefore concerned about the impact of this on its members and other postmasters who have invested in this network, and also the relationship which it must have with the Post Office to protect their members' investment. The NFSP considers the evidence so far demonstrates a pervading culture of cover-up, incompetence, knowingly doing wrong in relation to prosecutions, and an entrenchment of placing corporate considerations above legal obligations and human decency. The NFSP is concerned about how postmasters, their assistants and staff Crown Office employees and their respective representative bodies are meant to have trust in their ongoing relationship with a huge and powerful organisation which has not so far, on the evidence, demonstrated the fundamental cultural and moral change which is necessary as a result of the miscarriages of justice. In that regard, the NFSP looks forward to the inquiry's recommendations for the future in Phase 7, and I believe that concludes my submissions just within 30 minutes, sir.
So that was a fairly conclusive dismantling by the NFSP of not only the post office actions throughout the post office scandal, but also in their evidence to the post office inquiry, a number of witness testimonies that were referenced, as well as the conversations that were happening between post office employees, including the implicit destruction of documentation that could help undermine prosecution cases. It just goes to show the lengths that have been highlighted during Phase 4 that the post office went to when convicting what we now know to be innocent subpostmasters of horrendous crimes that they were accused of that they didn't actually do.
Well, you two are to be warmly congratulated on the quality of your submissions and your predictive powers.